Hi there, I'm James Dapperty, and this is Coffee and a Case Note. Is the presence of an Aboriginal object a defect in title? This is an interesting decision. It's one called Mehmet and Carter. Right, you and I are in a deal about some property in Byron Bay. I'm selling some land and the business on the land to you. At the start, we've got the same solicitor because things are going well. But as the conveyance progresses, you find out that there may be some Aboriginal objects on the land. Now, our poor old solicitor realises there's a conflict, and so off our initial solicitor goes, and we're then instructing two different firms. Things don't go too smoothly. The purchase price is that you're going to pay me $3 million. And so we start arguing about this sale and the two interdependent contracts being the sale of business, it's a resort we're running on the property, and the sale of land being the property itself. And what you say to me is, what your lawyer says to my lawyer is, there is a defect in the title because there are Aboriginal objects on the property, and because I, the vendor, doesn't own them, I am not capable of giving you, the purchaser, full non-defective title in the property, which entitles you to, among other things, potentially termination. But this is the basis of the dispute. And so the matter comes before the court to essentially ask, does the presence of what you allege to be Aboriginal objects, which allegedly include the remains of Aboriginal elders that are buried under the ground, does the presence of those objects entitle you to various rights, including potential termination under the contract? Right. So the court turns to the relevant legislation. Aboriginal objects are legislatively defined, that if no one owns them, then they vest in the Crown. So if no one owns them, then the Crown owns them, and they must not be, quote, quote, harmed. And harmed includes moved. So we have ourselves a property with alleged Aboriginal objects that the Crown owns that can't be moved. And what you're saying is, how am I going to buy this property? It's full of bones that I don't own, so I can't convey to you. And so this whole thing is going to fall apart. And what I say is, no, I never promised to sell you bones that I don't own. I never promised to sell you Aboriginal objects. I just promised to sell you the rights that I had in the property. The court then has to consider what the contract was. The conclusion the court comes to is on my side. The court says, yes, how can it be that a reasonable business person looking at this agreement from the outside would have expected that I was promising you rights to these Aboriginal objects that I didn't currently own, couldn't move, and probably couldn't even become the owner of in future. And so the broad question is, was the presence of the alleged Aboriginal objects a defect in title? The answer the court came to was no. And so I hope that quick little run through Byron Bay property development world assists you in understanding when Aboriginal objects might be a defect in title. And if I can go a little further to say, there might be a sigh of relief for a number of property vendors and purchasers who might have been watching that judgment closely. I look forward to you and I having another chat over another coffee in the future. Cheers.